Kemudian dia bersama seorang lagi penghuni wifi itu Bella. Jelas dia lagi penghuni Bella pada awalnya untuk ada seorang Siti Bainun.
Owner of Rumah Bonda Siti Bainun Ahad Azali, which is a home for children with special need in Malaysia. According to the news report, Bainun has found guilty of neglecting and abusing Bella, who is a Down syndrome teenager, 3 years ago. But Siti Bainun did not admit the wrong she had done, and she testified that she discovered the child injuries occurred sometime in May 2021 over an argument with two residents, Yasmin and Balkis. According to doctor testimony, Bella's body showed multiple scars, burn and wounds, and the doctor said the injuries were suspected non-accidental injury and had happened on multiple occasions. So that's shown that she has abused Bella on a daily basis for almost 4 months. Bella experienced injuries is burn, bruises, and cut all over her body. And other than that, she was forced by Bainun to eat the fried rice that mixed with many chili. Siti Bainun also instruct other residents of Rumah Bonda to hit Bella, and they are not allowed to tell others. Obviously, there is an battery occurred. In this case, Yasmin Nahar Mahmud, 18, a resident of Rumah Bonda, said the incident happened every night from March until 21st June 2021. Siti Bainun was charged under Section 31 Class 1 of the Child Act 2001 for neglecting and abusing Bella. This case began on 30 March 2022 and ended on 3 May 2023 when Siti Bainun was sentenced to 12 years in prison. For this case, we refer to the news on the Asra Awani, Free Malaysia Today and the Star website.
In this case, is the type of the trespass to the person is battery. The issue is whether the act of Siti Bainun abusing Bella, a Down syndrome teenager, can be considered as battery. The law is there are 4 elements must be fulfilled or proved by the plaintiff before accusing the defendant act as a battery. The first element of battery is the intention of the defendant to apply force. Touching a person without consent has traditionally been regarded as sufficient battery even though without actual physical harm. In the Scott against Shepherd, 1773, 2 YM by 892, a lighter squirt was thrown by the defendant into an open market area. The defendant was liable for the tort of trespass to person, although his initial gesture did not directly affect the plaintiff. Secondly, the act was under the defendant control. The defendant act must be done voluntarily. In the case of Gibbon against Piper, 1695, 2 Sock, 637, the defendant was riding a horse when someone hit the horse from behind, causing the horse to bolt. The horse collided with the plaintiff, and in an action against the defendant, the court found the defendant not liable as the incident of the horse bolting and colliding with the plaintiff was outside his control. The third element of battery is a contact or application of force occur. Any physical contact with the body of the plaintiff or his clothing will be sufficient to constitute force. In the case of Lindsay, 1995, 2 CRMR 6687, a shoplifter spat into the face of a police officer during arrest, and the court held that beating could not amount the battery. Meanwhile, in the case of Day, 1845, 1 Code CC 207, the concept touching the clothes a person is wearing can be considered as battery. The last of element is without plaintiff consent. A person cannot touch other person without their consent or without lawful justification. In the case of Nash against Sin, 1953, CLY 3726, the defendant found guilty for using the plaintiff's stone wreath without first obtaining the plaintiff's consent and causing the plaintiff to develop some skin complication due to adverse reaction to the thorn wreath. According to the court, the consent given by the plaintiff did not include the thorn wreath and its consequences. Battery was established.
Using the element of battery, in this case it was clear that Siti Bainun had intention to apply force when she abuses Bella, which caused her body showed multiple scars, burns, and wounds. The defendant was liable for the tort of trespass to person because Siti Bainun directly has intention to apply force towards Bella, which she aware that hit someone will cause of injury. Next, the act was under the defendant control, which is Siti Bainun can control her voluntary action from abusing Bella, who are Down syndrome teenager. Third, a contact or application of force occurs when Bella's body was found multiple scars and wounds, which alleged hot water incident could not have caused multiple scars and wounds. This means the injuries were suspected non-accidental injuries and had happened on multiple occasions. Lastly, she commits battery because of touching Bella without her consent and there is a harm occurs. act of Siti Bainun abusing Bella is considered as a battery, as defendant has the intention to apply force which the act is under the defendant's control, and there is a contact occurs without plaintiff consent that can cause the injury.
The defense available in this case is lawful arrest. Police and private citizens are allowed to make arrests in order to enforce criminal law, even if it interferes with the rights of others. While getting a warrant is preferred, sometimes immediate action is necessary to prevent harm. In this case, Yasmin Nahar Mahmud reports Siti Bainun acts to the police and she was arrested after being found guilty of neglecting and abusing Bella, a Down syndrome teenager. This type of defense is accepted in this case. Next defense available is self-defense. A person is allowed to use a reasonable amount of force to defend themselves or someone else from an unlawful use of force. In this case, Siti Bainun defends herself as she had testified to tell that Bella suffered the injury following a fight with two residents, Yasmin and Balkis, sometime in May 2021 that took place at the apartment's laundry room, and she wasn't at home during the incident. Besides that, Siti Bainun also stated that Bella accidentally hurt herself by pushing the button of hot water of the Kowe water dispenser that caused multiple burn marks on her skin. This type of defense is not accepted in this case and rejected by the judge because Siti Bainun was found guilty under Section 31 Clause 1 of the Child Act 2001 for neglecting and abusing Bella.